So, order. Welcome to the Public Accounts Committee on Monday the 1st of June. Today marks the start of our compensation week, where we are taking the unusual step in dedicating two separate evidence sessions to examine the government's administration of compensation schemes in order to highlight the importance of this issue. So based on the NAO's report on this subject, we will be examining operational performance of 7 schemes, including Windrush, LGBT financial recognition, infected blood, as well as 4 separate schemes within the Post Office Horizon scheme. As of February 2026, the government had paid around £3.5 billion across these 7 schemes, with an estimated further £11.4 billion potentially still to be paid. So today we are joined by a cast of witnesses who have a huge wealth of experience of some of these compensation schemes, and our session this afternoon is split into 2 separate panels. On Thursday we will then be hearing from senior government officials on the same issue. This afternoon we will be looking to hear from our witnesses about compensation scheme design, engagement, support for claimants, as well as recommendations for change moving forward. So we have a very important and experienced team this afternoon. I'm going to ask each of you, starting with you, Reverend Clive, if you would like to just introduce yourself, and then moving to your right, Sir Alan and Peter, and then Kate, please. So how would you like us to address you? Reverend Clive? Clive, how would you like us to address you?
Reverend Clive be fine.
Reverend Clive, would you like to introduce yourself, please?
So I'm the Independent Windrush Commissioner. My role is to act as a trusted voice for those people who've been harmed by the Home Office Windrush scandal, and to scrutinise and hold the government to account, and to make sure that we are advising with regards to some of the reviews from the Wendy Williams review.
Great to see you. Thank you very much for coming. Sir Alan.
Hello, I'm Sir Alan Bates. I led the Justice for Subpostmasters Alliance, which exposed the post office scandal after all these years. And even though I sort of stepped back nowadays from things, I think it was so important to attend this particular Public Accounts Committee. I thought it was well worth doing.
We're very pleased to see you. Thank you. Peter, former colleague.
Indeed. My name is Peter Gibson. I'm presently the Chief Executive of Fighting with Pride, the LGBTQ plus military charity that has campaigned on behalf of those veterans impacted by the LGBT ban between 1967 and 2000, supporting Lord Etherton in his report leading up to the government's apology in 2023, and representing and supporting many of those veterans who've applied under the scheme.
Very good to see you again. And finally, no means least, Kate, please.
Thank you. I'm Kate Burt. I'm the Chief Executive at the Haemophilia Society. So I'm here to represent the more than 6,000 people with haemophilia and other bleeding disorders who were infected with contaminated blood in the 1970s and the 1980s and were contaminated with HIV and hepatitis viruses, and over 3,000 of our community have died. The estimate is that around 30,000 people were infected in total, so I'm here to represent them all.
Well, we're very pleased to see all of you, and thank you again for coming. So we're now going to turn to the first question, please, and we're going to ask Matt to start us off, please.
Thank you, Chair. Good afternoon. This question is for each of you, because the experience that you have may be different dependent on your groups. How confident are affected groups that the compensation schemes will deliver outcomes that are proportionate and just?
Do you want to set an order? Do you want to go from
well,
right
let's
to
do
left?
it the same. Yeah, let's start with you, Kate, if that's okay, and then we'll work our way along.
I think proportionate and just is quite difficult to define, given that so many of our community were multiply exposed to harm, and indeed many people, including children, were subject to non-consensual and experimental testing. The harm that was done to them, the lives that have been lost, the children who've lost parents, the parents who've lost children, the devastation to the people in the bleeding disorders community is very hard to quantify. So although our compensation scheme, in comparison to some of the others in the room, might appear to be extremely generous, is it proportionate to the harm that was done over 40 years, not just the infections that were that were suffered, but the continual denial by governments of every political hue that this had happened. And as Sir Brian Langstaff said on the 20th of May 2024, this was not an accident. It could have been avoided.
Thank you.
I think the first thing I'd like to say, I think trust at the moment is still very fragile, and people feel like they have to be fighting the state all over again. Currently, we are seeing there is a high amount of nil awards. Out of 100 claims, 56 result in a nil award. This is damaging the confidence in the scheme. And so it is critical to understand that. That combined with the trust element and then the outcomes that over 56% not getting a positive outcome is very concerning. So my office is currently looking at to do an independent review on this so that we can understand why this is happening and then drive to understand what needs to be done to fix it. There is still an amount of emotional pain. People feel that there's the actual engagement with the forms is complex, and so it is damaging the trust.
Thank you. Mr. Allen.
Yeah, I think if I can say first off that post office schemes are often described as compensation, whereas the GLO scheme, something I went through, it was actually meant to be a financial redress scheme which included a proportion of compensation. It was meant to put people back in a position they would have been in had post office not done to them what they did. So I know compensation sort of wraps it up. It's become the common way of describing it. And the other thing I'd like to add is that, you know, any comments I make today are very much my own views, but they're also based upon my experience of being a victim and also leading the group over all these years. I mean, I think if you ask me what do I think about the compensation scheme as such that have been involved for the post office, I'd have to say they were utter disaster, to be quite frank. And there are just so many reasons why they were wrong and why they've caused so much grief even nowadays.
Thank you. Thank you. Peter.
I think the first thing to say is that our scheme is not a compensation scheme. The sums involved for our LGBT veterans are considerably smaller than any other scheme. And I think when we look back at it, I think it was accelerated because it was fairly straightforward. That's not necessarily been borne out in terms of the trust that's been experienced by veterans. They were promised 18-week updates at the launch of the scheme. Those didn't happen. The computer system that the MOD was using failed to materialise for 9 months after the scheme started, and those delays, compounded by the delays to the appointment of the panel, the impact panel, compounded by the delays to the setting up of the further impact panel to accelerate delivery, which has taken the Ministry of Defence since September up until the 18th of May to finally announce, has led to a great deal of distrust in the system. A number of our veterans who effectively were forced to resign are not included in the scheme, and that's led to some veterans taking a judicial review to challenge the scheme. And I think what I personally can't convey to you is the whole re-traumatising effect of our very damaged veterans who experienced not only the loss of their jobs, but the loss of their careers, the loss of their pensions, and the horror of being outed by the military to their families, that's had such long-tail consequences that's taken, in some instances, up to 60 years to receive any settlement. So, no, I don't believe it's proportionate, and I don't believe it's just.
Thank you. Thank you. You've largely preempted my next question, which is going to be about trust, and I'm definitely getting the sense that there isn't a feeling that that there is trust in these schemes. I mean, Kate, you didn't specifically mention that, but would you say the same thing? Do you think, or is there a greater level of trust?
The compensation scheme was fundamentally undermined up until the 20th of May 2024, when the Infected Blood Inquiry report was published. Government consistently refused to engage with us and with any of the other charities or campaign groups, saying that they must wait for the inquiry report to be published. Less than 24 hours later, they announced in the House a compensation scheme as a fait accompli. They'd clearly been working on it for months. I know Professor Sir Jonathan Montgomery is also giving evidence today. Why did his expert group meet behind closed doors in secret, so that when the compensation scheme was announced, it caused devastation less than 24 hours after the total vindication of Sir Brian's report? So no, there is no trust.
Thank you for that detail. And then finally, I'd just like to ask, from a perspective of now, are the schemes that each of you are concerned with doing enough to improve that claimant's trust? And perhaps if we go along the row again.
With the Infected Blood Compensation Authority, they are trying to engage with the community. Are they listening? I'm not so sure. What we're really concerned about at this point is that the claim system seems to have completely stalled. They have over 350 claim managers based in Newcastle, and at the moment we estimate that there's probably 30 to 40 live claims. So what's going on? They're obsessed with test and learn. The living infected, who were already recognised on support schemes, many of them have received their compensation, which is really encouraging. But the living infected never compensated. The estates of those who have died and the affected, which could be tens of thousands of family members, we have no idea when their claims will be opened. And it's just not good enough. IBCA has a budget of £171 million a year. They need to spend and get the claims through of people whose cases are quite straightforward because the evidence is there. They're refusing to do that because they want to create a perfect system so that everybody's cases can ramp up. But we just don't understand what they're doing.
Thank you for that. Sir Clive.
Well,
Reverend Clive.
There's been some improvements in the scheme since the beginning, but more change needs to happen. It's still not working for the communities and the people it was designed to do. So back in 2020, the timeliness, you were waiting up to 14 months to get a result on a claim. 2025 now, we're down to 4 months. And I have to say, with regards, I, as the Commissioner, made a number of recommendations to improve the scheme. Those recommendations include that we get advance payments for those who are in a review up to 75%. We get pensions that were lost are compensated. And that's a massive, important step. And also it was important that we understand that the priority should be given to older claimants, those who are 75 and vulnerable. All these steps are really important. They are incremental, but what we want to see is some more fundamental change. Now, it's really important that those changes were made because the delays in particular were totally unacceptable, how long people were waiting to get justice. And it's going to be important that the government realises that it's still a job that is not complete.
Okay. Thank you for that.
Can I just, before we go to Sir Alan, I wasn't entirely clear. You said it was important the changes you've announced were made, fine, but I think you then said that there's still fundamental change that needs to be had. Is that the case, and if so, what is it?
So I am really concerned what people are telling me is that they need some level of support, and this support is leading into what we call funded legal support. People find the process complex, overwhelming, and they find it confusing. And I am hearing from people that funded support, legal support, would be of benefit. And I think this will help also to address the kind of reviews that are very costly and advocates are doing a great job, but they do not do the work that lawyers can bring.
Thank you very much. So I'm sorry to interrupt.
That's all right. I think there's and talking to the others earlier as well, I think there's a fundamental problem with all of these schemes, and that is government shouldn't be involved with them. That's the biggest mistake about the whole thing. I mean, the civil service just grinds them into the ground. I'll give you a perfect example. The GLO scheme, which I was involved with, the minister announced that there'd be a compensation scheme or financial redress scheme in March 2022. It was meant to be completed by August 2024. A deadline was set for it. They didn't even launch the scheme until a year later. And the first thing the department did was get rid of the deadline, saying that it was going to be, we don't want to hinder anybody, we want to make sure people have plenty of time, etc., etc. Instead of working to a realistic timescale and actually getting the job done. And so it got bogged down in it, and I think that's been the big problem. It has to be an independent body. Government has to be involved at the highest level. It probably has to fund it, in our case, until the real guilty cough up towards it as well. And it has to have involvement and funding, as I say, from government. But I mean, it has to be an independent body, and there are a whole number of ways it could be achieved.
Well, we'll probably come on to that, because that's fundamentally important. But thank you.
And Peter,
I think that what I want to say to you is a number of things. There has been some improving trust on a number of levels. I personally have had very good personal direct engagement with the civil servants running the scheme. That's been welcomed by us, and I believe by them. They have listened. They accepted our advice to add financial challenges for some claimants to the list of accelerated criteria for payment alongside the terminally ill, which was welcomed. The transparency of the progress of the scheme, the Ministry of Defence's website publishes stats on a monthly basis. It took us 9 months to get them to do that, went into development, and if you look at those stats now, they are so opaque in terms of the progression of each of the respective schemes. They don't tell you that the discharge dismissal payment scheme is almost at 97% of payments, but what it clearly doesn't tell you is that the impact payment scheme is still sub 50% in terms of settlement. So there's a level of opaqueness about that transparency that kind of breeds distrust. From the very start of the scheme, we were concerned as an organisation that the government wasn't putting enough into advertising, marketing, promoting the scheme, because the Ministry of Defence does not have a list of all LGBT eligible veterans. Nobody has that list because of previously destroyed records and lack of information being held. I spent almost a year lobbying to get further funding to do more marketing, more promotion, more advertising to find those lost LGBT veterans. And the Ministry of Defence has now finally awarded a contract for £60,000 to a company 18 months after the scheme starts, 6 months before it finishes, and they've appointed it to an organisation. I hold no axe to grind with them. They've reached out to me on being awarded the contract, but they've reached out to us because we have the expert knowledge in respect of finding LGBT veterans. Well, in my personal view, that money would have been better given to us as an organisation to help find them a year ago. So the trust is there on some respects. There has been some listening. I'm still awaiting replies to various pieces of correspondence to government ministers in the Ministry of Defence. They've met with me on multiple occasions and I've welcomed those meetings. I've left memos, I've written follow-up letters. Those have not all been responded to. And the very fact that some of our veterans have had to launch a judicial review tells you, I think, all that you need to know about complete trust in the scheme.
Thank you very much indeed. Thank you, Chair.
Thank you, Matt. Thank you. Catherine, please.
I just want to start by saying thank you for being here. The power of your testimony is quite tangible in terms of the voices that you bring to the people, from the people that you represent in this room, and you can feel the strength with which you present those concerns. I have to say, Newcastle is the home of the Infected Blood Compensation Authority. I have been to visit the team there. They are incredibly proud and dedicated to be administering the process, and I'm sure they'll listen very carefully to the feedback today, and I'm sure the outcome of our report as well, because I think everybody wants to see this done in the best way possible, and that is obviously the intention of the questions today. I wanted to focus on looking backwards a little bit first, so my questions are probably to you, Reverend Clive and Sir Alan, on the Windrush and the Subpostmasters compensation schemes, but I take on board what you say about the redress. I think it's a very important point. What is it you think about how they were designed initially that led to their initial failure?
Well, I think having the people who were affected the most in the room to be a part of that design, I think, is something that is really critical. And I think that is something that I would like the committee to be aware of, and I think going forward as well. I think a big area is around trust, and in principle, I don't think having the department that has caused the harm then actually administering the justice is going to be helpful in building that trust from the onset. So that level of independence is crucial in terms of the design and the flaws. And I think co-design with the people who have been most affected is essential from the onset when designing the scheme.
In fairness, I think it started quite well as far as the GLO scheme. The officials seem willing to listen to ourselves and also to our lawyers who'd spent a lot of time fighting Post Office on our behalf. And they did sort of take on board a lot of the points, or I say they did listen to a lot of our points. But then the scheme that came out at the end seemed so different, and we were assured it was going to be non-legalistic and all the rest of it. It's got bogged down in lawyers and etc. And it seemed that the first thing the department did was to go out and hire a very expensive firm of lawyers to put the scheme together for it. I mean, which is mad, because it obviously didn't have the experience to do these things. And this is why I'm saying that I'll go back to this time again, Chair. An independent organisation needs to be on, where they're not reinventing the wheel every time for every different situation. There's some commonality in there. And it's like the Reverend Clive just said, the victims have to be involved, and their legal representatives have to be involved from the outset in the design of any scheme and any appeals process in there, so that everyone, everyone has a stake in it working out.
So I know it's been suggested, I think it was you, Reverend Clive, that claimants would need or would benefit from legal representation to navigate the system. It feels to me like the challenge that you're both putting is that these schemes are so complicated that anyone applying to them therefore needs legal representation. So what would you say to the suggestion that actually this needs to be simplified so that individuals don't require legal representation, and what would be your suggestions for achieving that?
Well, I think from the design of the Windrush scheme, obviously we know the government is saying you don't need legal representation, but the evidence is telling us that for people who are going through the process. It is very complex. And I'm sorry, but we have other schemes that are legally funded, and I'm sorry, but some of the problems that the Windrush generation and those who are going through the scheme, they're very complicated, and they require a legal mind to support them. And so if other schemes can have that legal funded, why cannot Windrush? I mean, I welcome the Advocacy Support Fund, but it's not enough. Legal support can provide the challenge of flawed decisions. We're seeing that people find it overwhelming and complicated, the level of evidence that's required. And so all those points towards funded expert legal support. And again, I think it will help and enable to come down and limit the costly reviews as well. So for me, I am hearing this and we're seeing, and my office is actually putting this to ministers, and we'll be looking at how we can present to ministers a bit of what we would call a cost benefit for this as well. And even the justice report that was done talks about, with the engagement of funded lawyers, we getting better outcomes for those people who are going through the claims process.
Do you have anything to add to that, Sir Alan?
Yeah, I think I'd agree with the point you raised, that it needs to be simplified in there. And I think it's got so legalistic. As I said, the department went away, hired a big firm of lawyers to put the whole scheme together. Well, the minute they do that, they've turned it into this enormously complex and threatening thing for the victims, who then need their own lawyers to start getting in there. And now you've got lawyers against lawyers against lawyers, and it goes on, and it costs millions every time to do it. So yes, I fully agree. A nice simplifying. I think most victims just want a fair outcome. They don't want to go through all this again, time and time again. They want to move on.
Thank you, Catherine. I was just wondering, when you were speaking, Reverend Clive, whether it's more difficult for schemes like yours, which happened a long time ago, and Kate the same, where often the records were pretty minimal, whether that's even more important to have legal representation to try and gather that evidence together. Is that correct, or is that nonsense?
That's correct, Chair, and I would really emphasise that it was the state who in many ways caused the records not to be available, and then people have been asked to provide those records as well. So that is something whereby I have to say, in my experience in supporting people, working with people, those who have got an outcome, you will tend to find that they have worked very closely with an experienced advocate, or they've had lawyers' legal support to get the outcome, and it's proving to be more complicated and complex than the initial design would lead to think so.
Kate, again, your scheme happened to many people far too long ago. Presumably a lot of the records are not there. This must be a problem.
Yes, in many cases medical records were missing or were destroyed. When the Infected Blood Compensation Authority was set up, and I absolutely take your point, they are a passionate and dedicated body of people, but they have inherited a deeply flawed scheme that was designed without the expert input of the community. The legal representatives who were throughout the inquiry fought to have a place to be advising the community, and we do have legal representation, we have financial advisors, we have psychological support, and that's a sign of how much damage was done, but I don't believe the other schemes have any of those things, and that doesn't seem to be consistent or fair.
Blake, please.
Thank you, Chair. My questions are to Peter and Kate in relation to the LGBT financial recognition scheme and infected blood compensation scheme, respectively. We've heard a lot of the issues and challenges from the other schemes. I think for me it would be really helpful for each of you to unpack the comparisons So compare and contrast. So have lessons been learnt, or are your schemes suffering the same challenges that the previous schemes or the earlier schemes have suffered? So perhaps, Peter, you could kick off, because you actually at the start gave a useful list of all the challenges.
Forgive me for not being over the detail of the other three schemes. I think out of all the schemes that are represented before you today, ours is probably the most simple, and has probably been administered in the fastest possible timescale. It's important, I think, that the committee realises that our scheme closes on the 12th of December this year. So if an LGBT veteran rocks up at our door just before Christmas seeking their reparations for their mistreatment between 1967 and 2000, the door is shut and they will get nothing. So that there's kind of an impetus about the urgency with which we believe things should have been addressed by the scheme because of that timescale. With regards to the scheme overall, it's a relatively simple and straightforward scheme, but many of our veterans are in their 80s. We've even had some veterans in their 90s who were impacted by this ban, and they're not technologically proficient. We've had to send some of our support workers to sit down face to face in veterans' homes to spend a day with them, to write out their testimony on paper for them to be able to submit it, because they can't submit it through an online portal. They've been re-traumatised by that process. It's a painful and hard process. We've been successful in securing, it's important to note as well, there is no provision for any legal representation in our scheme whatsoever. And I think for the majority of our veterans, they've been able to navigate it with our support without legal support. But for some, particularly those more elderly, those more vulnerable, those significantly mentally traumatised by their experiences, that legal support that they've been able to secure through the help that we've been able to negotiate with firms on either a reduced basis or on a pro bono basis has been remarkably beneficial. And I think, echoing what everybody else has said with regards to their schemes, every single one of these compensation schemes or recognition schemes should in the future provide for free independent advice for the applicants, because some of our LGBT veterans are having to dip into the very small sums of money that they're recovering to pay lawyers, albeit on a reduced rate, for the help and advice that they've got. That is not fair, that is not equitable, and that is not just.
Thank you. Kate?
I don't think lessons have been learned from earlier schemes. As I said in my opening remarks, we found out on the 21st of May 2024 that the government had been consulting with an expert group behind closed doors and in secret, which led them to announce the compensation scheme the day after the inquiry report was published. If they'd engaged properly and trusted the experts in the community, they would have saved themselves a huge amount of work. The third set of regulations are about to be laid before Parliament, trying to retrospectively fix the flaws in the scheme. And as I said, IBCA have been landed with the job of administering this scheme, and they have no discretion. So there is not much trust that although they are nominally independent of the Cabinet Office, our community doesn't believe they truly are. And they have no discretion under the terms of the scheme in any exceptional circumstances to do anything. And as I say, if the government had engaged early, when it became obvious, as it did in March 2022, when Sir Robert Francis delivered his interim report on compensation, that significant compensation was going to have to be paid, they could have used that 2 years to engage properly with the community, and many of the defects of the scheme would have been avoided.
And for both of you, to what extent have the schemes been successful in achieving positive outcomes for the individuals that have been affected? Maybe we'll start with you, Peter.
I think for many of our veterans, they feel as though they've finally got some closure and some acknowledgement. But I don't think that's universal amongst the entire community. The figures involved are relatively small when we're talking about people who've lost their entire careers and access to pensions. So for some, I think it would be fair to say those people who've largely gone on to have profitable careers and done well in their lives financially, but for others, this is the opportunity to buy their first brand new car, the first time they've had in 30 years to be able to afford to go on a good holiday. And so there's some acceptance that this is nice to have. It's a final acknowledgement. I think probably the most profound, and it'd be interesting to hear what the other panellists have to say in regards to this, the genuineness of an apology. The sums of money aside, the most profound, the most healing thing that our LGBT veterans experienced was the dedication of the memorial by His Majesty the King at the National Memorial Arboretum last year. That was the most profound and significant thing for them. So it's a very mixed picture as to whether the sums are enough, because I don't believe that they are.
And before I come on to you, Kate, there's 6 or 7 months left for veterans to claim, and so there's not a lot of time left, and I think you touched on this earlier in some of your remarks. What more needs to be done by government or anybody actually to ensure that the gap between those that are caught and those that are sort of miss out is as small as possible before the end of the year?
Well, I'm talking to a table of politicians who know how to lobby and campaign and raise their profile. £60,000 does not buy you very much, and to only start spending £60,000 18 months into this scheme, it's woefully inadequate. I would like to harness the support of every single member of Parliament highlighting this scheme to their communities, because our veterans are spread through every corner of the country, and indeed we've got veterans who live abroad. And so to my mind, no stone should be left unturned in seeking out the armoury of every government department to help uncover every single eligible LGBT veteran. £60,000 is not enough, just not enough.
Thank you very much. And Kate, back to my original question, which is around the positive outcomes that have been achieved. Would you be able to comment on those for your scheme?
I think it very much depends on individual cases. One of the inequalities that was baked into the compensation scheme was, when it was announced, was the varying tariffs of compensation. So if you were co-infected with HIV and hepatitis viruses, the amounts of compensation were over 2 million, and then depending on your mono-infection with hepatitis viruses and depending on the status of your condition, it could have been 500,000, 800,000, and people just didn't understand why the expert group had come up with these numbers. And there was nobody on the original expert group who had any knowledge of bleeding disorders or haemophilia, which was an extraordinary omission. Like Peter, I think, in the House, the then Prime Minister, Rishi Sunak, offered a fulsome apology and called it a national stain on Britain. And he was right. And acknowledgement of what harm has been done is really important to these communities. Compensation, of course, is money and is valuable and is a recognition of the lives that have been destroyed. But I can't think of one person who would rather not have the money and not have had the infections, or not have lost their children, or not have lost their parents.
If I may ask one final question, Chair, it's actually to Sir Alan. In response to a previous question, you said that actually the state should perhaps not be involved, and that would be one way to improve these schemes. Really? So in a perfect world, in your mind, how would these compensation schemes be designed without the state involved, without the civil servants and the bureaucracy involved?
I think that would be down to an independent organisation to actually create a framework and to create an administration that ran all schemes across the board in there. But then each individual scheme, because they're all very different as you hear today, each would engage the victims and their legal advisors to help design a scheme with the relevant professionals. But you would need legal advice along the way, I agree. But you'd only need it in one area, hopefully, at that time. And if the scheme was felt to be fair, that had been designed and had engaged everybody involved, then hopefully it would flow a lot smoother.
Thank you. Thank you, Chair.
Thank you very much, Blake. First question to you, Peter, really uniquely to your scheme. How important are the non-financial restorative measures, things like including restoration of medals, letters of apology, service ceremonies, replacement of catch, badge or beret, and the Atherton ribbon? Of course, people need financial compensation for the hurt and trauma that they've gone through, but how important are these other things?
I think for many of our veterans, those are incredibly important. The ability to march at remembrance wearing their original beret with their cap badge, the pride with which our veterans are wearing their Atherton ribbon, which acknowledges the hurt and harm that they suffered, are incredibly appreciated. I think the Ministry of Defence can learn some lessons about how we've got one particular case. It's been highlighted on the floor of the House in respect of Chris Dennis, who was dismissed from service just several months before the passage of the Sexual Offences Act, and it's been a struggle and a fight just to get him a beret, and there are many things that could be done to make that kind of easier for those who fall outside of the parameters of the strict scheme, that would go a long way to help restore pride and justice for our veterans. But I think every single one of our veterans that has received their Atherton ribbon, either that they've chosen and opted to have it sent to them, or they've chosen and opted to attend a very moving reparation ceremony in front of a senior member of the armed service that they were in, has been hugely restorative for them. So I wouldn't underestimate those in any way, shape or form. Giving our veterans who did serve, whose service is just as dignified and just as important as anybody else who served, is vitally important to those veterans to restore their pride and dignity, and we use the phrase putting them back on the road to the military family, which is what we as an organisation have sought to do.
I now want to follow up with all four of you Blake's question about how you would do it differently in the future. And I'm deliberately leaving you last, Kate, because you're an independent delivery commission. And starting perhaps with Peter, you. I mean, all three of you, the words that have come through time and time again and from all of you are trust and independence. So I'm wondering whether we should think about some sort of permanent independent commission that would not only have a part in designing any new schemes, because they'd have learnt from the previous one, but would be, I mean, three of you certainly are very close to your ministries, and I think that doesn't help trust. How would you design a scheme in future? What would the structure of the scheme look like, do you think, in an ideal world?
Well, I would like to think and hope that a scheme like this is never required again for LGBT veterans being dismissed from the armed services.
But other things will be.
Yes, of course. I think it's important that promises should not be made that cannot be fulfilled. Our veterans were let down by a promise of a regular update, which they didn't receive. The scheme was launched without the software that they wanted to use being fit and ready for purpose. The level of transparency had to be fought for. I've alluded to and talked extensively about the lack of awareness. So I think, transparency from day one, transparent engagement. Don't make promises that you can't keep, only make promises that you are going to keep and fulfill. Access to legal advice from day one for applicants, I think would be the key benchmarks for any scheme, regardless of who the beneficiaries are.
Well, I'm sure you've thought about this lots.
Yeah, I think true independence. And that would be very key, that people saw that there's true independence. And I'll give you an example of why something like that is so important. There were over 700 convictions overturned at one point, as you well know. They then tried to contact these people, and don't hold me to these figures because they're off the top of my head, but it was only like 100 or so that came forward. And no matter how many people wrote to them, different departments or whoever, tried to get in touch with these other people to come forward, they wouldn't. They'd lost trust in the system, and they wouldn't engage with these people. So it has to be a totally independent body that can be seen to act independently and have the authority to do so.
Thank you. Thank you. That's very helpful. Reverend Clive.
Well, Chair, I think one of the main things to consider as well is that in the design of the scheme, it is trauma-informed principles that are aligned to the design of the scheme. The amount of damage that has done by the Home Office Windrush scandal to the Windrush community has been very severe and very deep. We are still seeing that is intergenerational in its impact. And the very people who are being then asked to go through and get redress through that process are being re-traumatized. So having trauma-informed principles from the onset is really important. And I just want to emphasize the emphasis on co-design from the start is critical for the scheme.
That's very helpful. Thank you. Kate, no, I deliberately left you till last because you are a delivery authority. I was going to say independent delivery authority, but you're not because you're set down by statute from government. But what ideas would you have in future of how government could produce an organisation that would be independent, that would be trusted, and would be able to design proper schemes?
Yeah, I represent the Haemophilia Society, which is a charity, but the Infected Blood Compensation Authority has many of the right principles. You know, they are independent of the Cabinet Office, although our community do not believe that. They are based in Newcastle in their own building. They have a system of claim managers. I think they're still learning a lot as they go along, which is understandable, because the expert advice was not there when it should have been. 2-3 years ago, when the scheme was being designed, as I say, in secret behind closed doors, huge mistakes were made, and now we're trying to retrospectively fix them through new regulations. So, as Reverend Clive said, co-design is absolutely critical. An independent body is absolutely critical, and not constantly having to reinvent compensation schemes and not have them attached to the department which has done the most harm. I find that extraordinary that Peter's having to deal with the MOD and Reverend Clive with the Home Office. At least we have the Cabinet Office, not the Department of Health, as our sponsoring department.
And poor Sir Alan had to deal with not only the DWP but the Post Office as well. Sarah Green, please.
Thank you, Chair. I'd like to go back to some of the conversations we've already had around support for claimants, just to get on the record from all four of you, to what extent those making a claim are getting sufficient support to do so, because it sounds like they are sourcing it from different and sometimes dipping into their own pocket. So I'd be keen to ask from all of you how that's working at present.
Okay, I think it's probably important to separate off legal support from emotional, psychological, mental health support. We, as a charity, we received a small sum of money from the government to provide assistance to veterans making claims. That has put a significant burden on our very small team of staff. There are only 12 of us to provide that support to veterans. So we've then had to rely on other agencies, NHS through Op Courage, other armed forces, military charities to provide mental health support to our veterans, and we've had to build up a patchwork of that, which has been a hard piece of work to do in itself. And the demands and needs of each individual veteran, that they don't all come in the same shape and size, and the impact on them is not all identical. This is a really traumatic experience for people reliving one of the worst experiences of their lives, sometimes 30, 40, 50 years later. And so I think There should be some dedicated support, trauma-informed, as Reverend Clive has said, that should be built into every system for an applicant, together with and separate to legal support. It was us that went out as an organisation to recruit legal firms who were willing to provide support to us, some at reduced cost, some on a pro bono basis, and that's been invaluable to those, and particularly invaluable in respect of the work around the judicial review that some of our veterans are having to take, because the issue that those individual veterans are facing, we've talked to the Ministry of Defence about. We've raised this concern. We've had that concern dismissed, ignored, dispatched, and so regrettably we are having to go to that stage to support those veterans to get justice for them. So mental health support, tailored, bespoke, holistic to the individual, together with access to legal advice, independent legal advice, would be essential.
Really helpful, thank you.
I think all of us here are coming from a slightly different angle, but we all sort of representing victims. I think as far as the post office victims go, we are fortunate, certainly the GLO group, we're fortunate enough to have legal support in there that have followed them through all the way, so that they have got something in there. And I know the lawyers, there are 3 main firms in there are others involved as well. And I know that they extend the range of what sort of support they can offer to a victim as well, where it's needed, and bring it in. But we've had, last week, we had a meeting with the Metropolitan Police, who have got an investigation ongoing at the moment into Post Office Horizon and the witnesses as well. And I was reminded at that point that the victims now, it's been accepted that they are actually victims of crime, and they can actually use the support services that go along with that. And I don't think that's something we've promoted to the group, and that's something that we need to do in the future to see how they can take advantage of that.
Thank you.
Okay.
Well, I have to say that the support is very patchy. And we see this with the nil awards, 56 out of 100 resulting in no payment. Very much heavily supported in terms of support by charities and volunteers, some really strong advocate communities that an organisation has been doing it from the beginning. Windrush National Organisation, Justice for Windrush, Action for Race Equality. And they have been the mainstay of driving. And then you have pro bono lawyers who were supporting people, because as I mentioned earlier, the complexity and the legal support was underestimated. I do welcome the step of 1.5 million advocacy support fund to help support. This is going out to communities and organisations, but it's not enough. It's very variable in the capability of those organisations. There are gaps in terms of the level of support, and particularly at the review stage. And I'm very concerned about long-term sustainability with that fund as well. So advocates are playing a really important role, but they can't do the job that lawyers can do, as I've said earlier. Funded legal support is essential for fairness. And that's what the victims are saying. They're finding it complex, overwhelming. And so I'll be pushing for ministers to look at models in which we can get this support. And as I mentioned earlier, other schemes have it, and that support is becoming very much more apparent.
Thank you.
I think once a claim begins, you are assigned a claim manager by the Infected Blood Compensation Authority, who stays with you through the duration of your claim.
The same person throughout the process, right?
Which is, I believe, working really well, and we're hearing anecdotally good feedback from that. We do have legal support that kicks in once your claim begins, and financial advice and psychological support is available. My concern, as I said earlier, is that the claim process appears to have stalled because IBCA are in this test and learn process where they want to get it perfect before they ramp up the estates of those who died, the living infected never compensated, and the affected, the family members. And that's what we don't understand, why you wouldn't put cases that are relatively straightforward because there's a link to an infected person, get those claims through. Why wait for the most complicated cases? It's like being triaged in A&E, but it's on when you walk in, not have you got a potentially fatal injury or a broken wrist. It doesn't make any sense to us.
Thank you. Thank you very much. I may stick with you if I may, Kate, because I'd also like to ask how transparent the compensation, the various schemes, whether they are compensation schemes or otherwise, how transparent they are about the claims process and the likely level of compensation an individual may receive. So it's like a transparency piece, if that makes sense.
Well, IPCA very helpfully produced calculators so people could go online and start to have some sense of the levels of compensation that they might be get. In terms of the claims process, it's complicated because of medical records, because the clinicians involved will say they get very frustrated with being asked inconsistent questions about tests that didn't exist, for example, for hepatitis C or hepatitis B. So the claims process itself, because they didn't have the expert knowledge within the expert group or indeed within IPCA to design the claims process properly, it's inconsistent. And I know that clinicians in haemophilia centres will say that they are extremely frustrated by not having clear guidance on what they have to produce, and then IPCA say, your claim's being held up because we can't get the information from your clinician. Well, the clinician can't produce a test that didn't exist in 1992. So this is the expert knowledge that was missing in the design of the scheme. Yeah.
Thank you. If I may ask you the same question around the process and how transparent the likely level of compensation actually is.
Well, knowledge of the scheme has been fading over recent years. This has been probably the longest of the compensation schemes. I've recently gone out on a UK tour talking to communities, and what we are hearing is that people are losing their knowledge of what the scheme is there. Is it still open? Can I still apply for it? And so I think we're starting at that level of a deficit. There has been some improved engagement from the Home Office with communities over the recent years, but the thing that is apparent is that there isn't what I would call more like an intensive national awareness of around that the scheme is still open for the status and for the compensation. And so within that regard, there is a limited amount of information getting across accurately, and we're still hearing, as it were, misconceptions. I think you could clearly understand that the public knowledge of Windrush in the media is always very negative. And so if communities hear that, and if communities are hearing people are saying, I've applied and I've got a nil award, then their lack of their engagement is not going to be forthcoming. So I think more work needs to be done to raise the transparency and accessibility across the schemes.
It's really helpful, thank you. I ask you the same question.
Yeah, it's a bit different with the post office scheme because each case is its own, and everyone, there's not a lot of similarities between cases, which is why we've had lawyers that are involved in there. The only difference is that there have been where thresholds have been set, where you can take an offer up to X thousand or whatever, and then people have been able to make their own judgment on whether they go on there without going to legal aid or legal support to make their decisions. So it is tricky. It's not ideal in any case, but it is a way forward. And as I say, they're all very, very, very different in the post office scheme.
Thank you.
I think with to separate out the discharge dismissal payment from the impact payment. The DD is very clear. It's £50,000. Were you dismissed or discharged, that's the figure that you will get. So that's pretty clear. The anomaly comes for those individuals who were forced between a court-martial and imprisonment or forced to resign on the day, taking the resignation option, and have now been excluded from the scheme. So there's a concern there which you will be aware of. With regard to the impact panel, it seems that the hardest amount of work required from our veterans, the most painful, re-traumatising work to write a statement, is required for the smaller amount of money. I think where the Ministry of Defence got this right with regards to the panel appointments are largely made up of known members of the LGBT community. That's provided some reassurance and some strength and faith that people known to our community are sitting on those panels. The individual deliberations of the panels are not disclosed to us, but what we have been able to discern is that those individuals who've had legal advice, or those individuals who have put their heart and soul and opened Pandora's box and made the most possible effort in writing their really harrowing accounts, achieve several £1,000s more on the impact payment than those who put less information in.
That's really helpful. Thank you very much. Thank you, Chair.
Thank you, Sarah. Anna Dixon, please.
Yes, thank you, Chair, and apologies, panel, for coming to the session late. I just wanted to pick up partly from experience of one of my constituents who's an LGBT veteran, is the issue of evidence, but it may be that this is something that's common to the other schemes as well. In that, although there seemed to be some very compelling evidence that she had provided to the Ministry of Defence, and indeed they had their own records, this was deemed sort of insufficient, and she was being sort of made to go and find all sorts of other, quite personal, obviously in this case, evidence. And so I just wondered what you were finding about the inconsistencies and the evidence requirements, and whether you felt that these were maybe too onerous, particularly on those seeking compensation.
So I think as this scheme approaches, I think that somebody should be appointed by the scheme to go back and start reviewing cases for consistency. Those decisions that were taken in the very early days, particularly of the impact panel, when they hadn't made any assessments whatsoever, but they've now got a body of knowledge that they can go back and actually look back and say, have we been consistent here? I think there's definitely an argument to say that that should be done. I think the way that the Ministry of Defence has interpreted the reverse burden of proof, which, for clarity, this scheme for LGBT veterans has a reverse burden of proof. The normal rule is that somebody who claims something has to prove it. Under our LGBT veterans scheme, it's effectively not on the part of our claimant to have to actually prove their thing. It's on the behalf of the Ministry of Defence to disprove it. And it hasn't been that consistent, I have to say, in my view. There's a whole multitude of problems with regards to evidence, the destruction of historical records, the fact that where records haven't been destroyed, there are ridiculous inconsistencies. I can point you to the example of a gay man that was dismissed using a code to describe him as being pregnant as the reason for his dismissal. So there's a lack of faith in the actual records that are found and uncovered. And in respect of subject access requests, many of our veterans, based on our advice, was to get hold of their records. Subject access requests have not been accelerated or prioritised in any way, shape or form. And we still have many veterans who are still waiting for their records to be dispatched to them because they want to see their records before they make their application. And in my view, that should be a priority for the committee's recommendations immediately now, that the Ministry of Defence should make those subject access requests a priority now, with only 6 months to go in respect of the scheme.
Thank you. And if if there are similar issues about burden of evidence and proof or consistencies that you haven't already covered earlier in the panel, be very pleased for you to also add any insights. Reverend Clive. Sir Alan.
Sorry, I
yeah.
think you covered that.
Yeah.
Well, yes, we are seeing within Windrush the requirement for the level of document information when that information isn't there. I mean, some of the historical injustice records go over decades, and then trying to find that, I mean, people just don't know where to start. And so that is something that we are seeing. In terms of inconsistencies as well, some of the decisions, sometimes we have to, I'm hearing people having to go through a review and qualify them because there is a part of the compensation scheme related to close family member impact. One member of the family gets compensation, the other member of the family, the other brother, 0. And then they go for a review, decision overturned. So we're seeing some inconsistencies there with regards to close family members. So 30% of the cases go into a review, and so that is showing that there is still challenges there with the decisions. I think the big concern that I have is how are we getting to the right decision first time, and then not creating an overburden on claimants to find paperwork which inevitably is not at hand.
Sorry, Sir Alan, did you?
No, I mean, I think it's pretty well known that with the post office issue, disclosure of documentation was a major problem, and it has been all the way through. And even with Sir Wynn's inquiry, I know they've had enormous problems obtaining documentation in there. And even I mentioned that there was the Metropolitan Police meeting with a victims group last week, and even at that it was mentioned that they're still struggling to get disclosure, and they're up to, I think, 1 billion pages of evidence so far gathered, and they've still got another X years to go. I mean, it does make you wonder what people are sitting on and how long they've been sitting on it. So disclosure is a big problem. Yeah.
Yeah, I mentioned earlier that in many cases medical notes are missing or have been destroyed, but also trying to find the date of infection when a test might not have existed for hepatitis C. How would you know the date of infection? Ireland had their infected blood inquiry over a quarter of a century ago, and their chief executive of the Irish Society gave evidence to the infected blood inquiry and just said the date of infection is the date of your first exposure to factor 8. It was contaminated. So unfortunately that advice wasn't taken on board. So when we move onto the estates of those who have died, I think this problem is going to get dramatically worse for families having to try and provide evidence for someone who's dead.
So would you in that case wish to sort of shift a little in the way that the veteran scheme is set up to almost assume that there was an infection unless somebody on the scheme could prove otherwise that person wasn't exposed?
Well, almost 100% of the haemophilia and bleeding disorder community were infected with hepatitis. Almost 1,300 were co-infected with HIV. 380 of those were children. Most of those are dead.
Terrible.
Thank you, Chair.
Terrible. Can I ask you a specific question, Peter? Your scheme closes on the 12th of December. Mm-hmm. What are you doing to promulgate that fact to make sure that those who are potentially eligible for the scheme actually do make an application before that date?
We're seeking out our battle for lost veterans. We're seeking out those people who are missing from our community. These are people who were turfed out of the military and wanted nothing more to do with the military because of how they were treated by it. The psychological scars that they've faced has meant that in many cases they've lived very isolated, closeted lives, and so there's a real challenge in trying to find them. They're scattered all over the country. The age profile is such that Some of them are in nursing homes, some of them are in care homes. We're a very small charity with very limited resources. We're doing everything that we can to amplify that message. I can tell you it felt like a kick in the teeth from the Ministry of Defence to tell us that we didn't have sufficient experience to run their scheme and spend their £60,000 on marketing the scheme, despite us spending a year telling them to spend the money. We haven't got the resources that this really needs. This is a £75 million scheme, and I think that the government should be doing everything that it can, harnessing its resources in departments like the DWP. They know who every person who was a veteran out there. The Ministry of Defence knows through the Office of Veteran Affairs every single person who's eligible for a veterans card. Why are they not writing to every single veteran out there and saying, who did you know that you served with that was kicked out for being a member of the LGBTQ community between 1967 and 2000, and tell them about this scheme? It just makes perfect common sense. And yeah, it's incredibly frustrating. It feels especially frustrating for me, for somebody who served in the government when this apology came out and was working alongside the then Veterans Minister when that apology came out, to see the lack of kind of drive and impetus to really make sure that every single person is found. Government's got massive resources to be able to do it.
Thank you. Chris.
Yes, thank you very much, Mr. Chairman. Just a quick question, just one question on just the structure, because I know you've commented to Alan about having an independent body. So if you look at different countries around the world, Australia, for instance, has a standalone national redress agency. The United States has special masters sort of projects. Canada uses third-party administrators. I was just wondering if I could just tease out some of your thoughts, if I may, on maybe some examples around the world, or where your thoughts would lead to about what type of body we should be looking at in this country, if you have any developed thoughts on this.
Well, I think it's the governance of it that would be key to the whole thing, and you need like a board like us here that's recognised nationally for the type of work that they've done, and also are prepared to fight for it as well, and show and prove their independence if need be. You say that these other schemes, I'll be quite honest, I haven't looked into the schemes themselves. All I can see is the problems with the schemes in this country, and what you need to remove from the schemes to try and get them going. I think you certainly have to start by taking lessons, I say, or hearing from a whole host of other people who've been involved. The lawyers have been involved, the victims that have been involved, how they want to be. I think there is a need for a forum to actually start to develop something. And then as you get an executive, or once you start forming some sort of organisation, then it's down to them to come forward with their scheme of how they want to take that. And they can take lessons from these better schemes around the world.
Thank you very much. I'm just cautious of time, Mr. Chairman. So if I could just focus on 2 points, if I may, because I know you have covered other answers with other people, so I won't dwell on those. One of the successes has been balancing the speed with accuracy. They've introduced fixed sum tariff offers in some schemes. Would you say that has been a successful approach in the programmes that has been offered in, and would you say that that's something we should look at in future for all schemes?
It has worked for some people, and for a lot of people that have just wanted to move on and have got on with their lives in the interim in there, where they haven't had very serious damage in there. But the big concern now is, I know there are certain people in there who have taken these amounts and then realise later on they should never have done it, because a lot of the victims, they're in a very bad way financially, and the fact of picking up £75,000 easily in a few weeks, if they agree to it, makes a huge difference. But they're perhaps not doing themselves, the true value of, they're not receiving the true value of their claim. So there's got to be some sort of way that they can go back and review, if at some later stage other evidence comes to light that have affected them, that had been covered up over that period, or the parameters have changed regarding some of these schemes.
Does anyone else want to add on that before I go to my final question?
I would simply say that there's some significant lessons to be learned, particularly about LGBT veterans from Canada. The Canadian Purge Fund was put on a statutory footing with significant endowment from the government to deal with the long-term consequences for the LGBT community. That's something that's clearly missing from our scheme here in the UK.
I'd only add that fixed tariffs need to be explained properly. One of the problems with our community is that there's no clear definition of why co-infected with HIV and hepatitis as opposed to co-infected with different hepatitis viruses and having cirrhosis of the liver, the difference in compensation was as much as £800,000. Nobody's explained it, been able to do that. And for those that were unethically tested on, some as children, people with bleeding disorders, originally the compensation awards were going to be £10,000 and £15,000. Nobody could explain why. In the latest set of regulations, they've improved that to £35,000 or £45,000. But again, there's been no explanation. How have you arrived at a number about a child who's been multiply exposed to a virus and unethically tested on and say it's £35,000? Where is the explanation for how that number was arrived at? So fixed tariffs could work, but they need to be defined.
Okay. And just my last question is just around, you in fact, Kate, you raised this. There seems to be, in this coherent theme, is a lack of trust here between the individual and the body, sometimes because it's associated with the Department of Defence in your example, sometimes because there's a lack of trust in the government to deliver these. Could you recommend, assuming whichever body we create, or hopefully might be created as a recommendation from the NAO, how would you go about in terms of resetting that trust? So do you think that people should be involved before an organisation is set up as a sort of a statutory consultee, that they have to be part of that process, or do you think there should be a requirement to recruit from certain organisations? How would you fix that disconnect that we currently see throughout, and that's a common theme throughout some of these compensation schemes?
Yes, I think it would need to be co-designed with representatives of the different communities who have been through all of this terrible trauma, because they are the experts on what worked well, what didn't go well, and how we can truly learn from Post Office, from LGBT veterans, from Windrush, from Infected Blood, from Grenfell, from Hillsborough. I mean, the list goes on and on, doesn't it? But the lack of trust in us as a community is reflected straight back to the lack of trust in anybody in positions of authority, and that's because truth and justice was denied for decades. So anybody in authority is immediately looked at with suspicion.
I think what is evident, all of us here have come from different angles, and each of our own sort of campaigns have their own particular strand of things. I was talking about an independent body, an oversight body, but each scheme that it ran would be very different to the next scheme. But it would be put together and managed overall by one organisation. So we're not reinventing this wheel time and time again. And everyone then brings in their own experts, their own victims to have a say on how their particular scheme should run.
Thank you for making that clear. That's what I understood you meant, but I appreciate that. Thank you, sir.
Thank you, Tris. I've just got one final question, and I'm going to start with you, Sir Alan, on this. Whether it is possible in designing schemes, compensation schemes, to make them into non-litigious schemes. It seems to me that perhaps you would never have got anywhere if it hadn't been for the court case. So whether that's an impossibility or not, because clearly if you could design them as non-litigious, they could be quicker, they could be cheaper, the victims would get compensation quicker.
Yeah, the schemes came after the court cases. But we would never have got the schemes if we hadn't actually achieved the two judgments that we did. I mean, the TV drama was fantastic, but it was those judgments that made the big difference in all of this.
I thought you would say that, but I wanted that on the record. I mean, does anybody else have a view on that? Non-litigious conciliation type schemes, does anybody have a view on that? If not... So in order, I mean, a court case, particularly if it's got to go through the full court case and then go to appeal, takes a long time for the victim to get their money.
Well, so Geoffrey, if I may, LGBT veterans in this country had to go to the European Court of Human Rights in 1999 in order for the ban on their service to be declared illegal. Nothing then happened for our LGBT veterans until the Defence Select Committee's review in 2022. And thanks to the wonderful work of Lord Etherton coming up with his recommendations and scheme. So we've been lucky in that we haven't had to have litigation for many, many years. But now, because of the inadequacies of the scheme, some of our veterans are having to go to litigation.
Either Reverend Clive, Kate, have you any views on this?
I just think that for, Sir Alan mentioned it earlier, what people want is fairness, justice, and that it's swift. Justice delayed is justice denied. And, with Windrush, people just want their dignity and their sense of belonging and respect identified. And we recognise that sometimes that may require a court procedural process. But at the heart of it is that sense of justice and fairness is delivered.
Anything to add, Kate?
Just to say, I do believe that members of the bleeding disorders community will start to take legal action where they feel that the compensation they're being offered is not proportionate to the harm that was done to them.
Well, in closing, can I thank all four of you very much. You've given us some pretty harrowing evidence. Your evidence is very important to this inquiry. We will consider, we've got a transcript, a verbatim transcript, which will be an uncorrected version of it. It'll be available the next few days. But we will consider your evidence very, very carefully indeed, and hopefully come up with some recommendations that will help people, not necessarily in your schemes, but people in future. And so can I thank you very much indeed. You're all busy people. Can I wish all of your members who are claiming compensation swift justice, and hope that they do manage to succeed where their case is warranted. I'm extremely grateful for you coming to today. Thank you very much indeed. Order, order.
Mm-hmm.
Order. Welcome back to the Public Accounts Committee on Monday the 1st of June 2026. We now move into our second panel of witnesses as part of today's compensation scheme hearing, and we've got two very eminent witnesses to be here with us. I'd be most grateful if you would both introduce yourselves and just say what your background to all of this is. So perhaps, ladies first. Shaila, I hope I've got that right. Your pronouncing of your Christian name, is that correct?
Yes, that's perfect. So Geoffrey,
Good
thank
afternoon
you.
and welcome.
Good afternoon. Yes, my name is Shaila Powell. I'm the director, a supervising solicitor and a reader at King's Legal Clinic, which is part of the law school at King's College London. For many years I practiced as a refugee and human rights solicitor, and for the last 15 years I've been teaching and running pro bono clinics at universities. So King's is part of something known as the Windrush Justice Clinic, which is essentially a group of community organisations and universities that provide pro bono representations to victims of the Windrush scandal. So our Windrush Clinic has been running since 2020. So as well as our students working on compensation claims, I've carried out research on the Windrush Compensation Scheme and redress schemes more generally. So I wrote a report in 2024 which compared the Windrush Compensation Scheme to the then Horizon Shortfall Scheme and the Lambeth Children's Home Scheme and the Infected Blood Scheme. We've also done working with impacted communities. So we did a roundtable report, and then more recently in February 2026, I've interviewed some claimant lawyers from the various post office schemes and the Infected Blood Scheme to understand their experiences, to prepare a briefing for the Windrush Commissioner as by way of a comparison. That's not in the public domain yet, but we hope it will be shortly. Thank you.
You've just put it in the public domain.
Oh, well, yes, yes.
I mean, if you don't want it in the public domain, we'll have to find a way of getting it out of the trunk.
No, it's fine. I spoke to Reverend Clive and he's fine. So we just haven't published it yet. So thank you.
And Sir Jonathan, we're very pleased to see you. Would you like to introduce yourself, please?
Thank you, Sir Geoffrey. So I'm Jonathan Montgomery. I'm Professor of Healthcare Law at the Faculty of Laws at University College London. I'm here primarily because I chaired the expert group, about which you've heard some in the earlier session, which initially started with one group and became a technical expert group when members were added for the third and fourth and possibly fifth set of regulations around the Infected Blood Compensation Scheme. I do have also experience of sitting on a panel of inquiry into maternal and neonatal deaths in Cumbria and Morecambe Bay, but that was not a compensation scheme process. So I'm primarily here to be able to speak to the design of the Infected Blood Compensation Scheme. I do teach more widely on healthcare law and torts law as part of my professional background.
We're very pleased to have both of you. You're obviously extremely well qualified in the subject to give us evidence, so it's really good of you to be here. Busy people, thank you very much for coming. So we're going to start with Catherine McKinnell, please.
Thank you, Chair, and thank you for being here. Based on your experience, I appreciate in a perfect world none of these schemes would be required, but given that they are, what would be your advice for how we best design and plan a compensation scheme that meets the requirements that would apply to the four schemes that we're looking at in particular today, but across the board and also into the future? What would be your advice on how these things should be better designed to deliver fair and swift justice?
I'll go first. I can speak particularly from the infected blood experience to the financial elements of compensation, but I think it's very important to recognise that redress has a number of other elements as well. In the infected blood context, it was clearly far too long before the harms were acknowledged. By the time my group got involved, there was on the public record a very clear understanding of a range of things that had gone wrong, brought together by Sir Brian Langstaff and government acknowledgement of the issues. So I think there's a divide between those redress schemes and compensation schemes which need to start with acknowledgement and the type of technical work that my group was asked to do. it would be completely wrong not to have those investigations and acknowledgements as part of the scheme. If we're dealing then with the financial elements of a redress scheme, and I've written to you, and I hope if you haven't seen it, you'll have. My reflection on the work that we did was that we were given what was a relatively technical job of taking an architecture that Sir Brian Langstaff had set out, and then trying to work out how to implement that in a bit more detail. And that architecture was essentially built on a recognition that there was wrongful action by the NHS initially, and therefore a model would be a clinical negligence type of compensation scheme, or what lawyers call personal injury. There was, of course, then overlaid a whole series of additional wrongs that community suffered by being denied that they'd been wronged, by a series of first attempts at financial support and compensation, which didn't go well. But the model that we were given was based on if this went to a court action, broadly what would the likely financial outcome be? And that did give us a series of benchmarks. So you heard earlier, for example, about the level of unethical research award. Sir Robert Francis, in his reflections on the first report that my group produced, looked at judicial decisions and came up with the original figure that has now been increased by reference to judicial decisions. So that figure had an explanation. I think it's very important to recognise that the timing of the explanations of the scheme, the publication of our report, the publication of an explainer by the Cabinet Office, and the announcements about response to the overall Langstaff inquiry made it impossible for the community to find a way through those explanations. So there's a learning point about being really clear in my mind what is the ask of the compensation scheme, what it's supposed to achieve, and then what is it that is flexible in that and open to discussion, and what of it is given. So when we did have the chance as an expert group to engage with the community, I think we saw two things. One was that the community produced some very well-reasoned, very well-informed improvements to the scheme, some of which we were able to recommend be picked up. But a second was that there were a number of people who didn't think that was the right model for a scheme in the first place. So I think in terms of expectations, it's very important that the community understands what government is considering and what it's not considering. And we would have been much better able to give advice in one go had we been able to discuss that with the community. But there were a number of things raised we would have said, well, that's outside the scope of the advice that we can give, because it's different to Brian Langstaff's recommendations.
Can I just take you back to, because I think what I've picked up there and what came across very clear in the advice that we had from the previous panel, in particular from Kate Burt from the Haemophilia Society, is that had the community been engaged at an earlier stage, then it would have been a better scheme. And you seem to be acknowledging that as well. Could you just clarify why that was not possible? Was it to do with the framework that the government set out that prevented you from engaging with the community in a way that actually would have been helpful to you?
Our terms of reference prevented us from meeting directly with the community. We raised on a number of occasions that would have been a helpful thing to do. In the second group that I've chaired, we have been able to do that, and we've had a series of round tables. So that was not a decision that my group took. I think there's something around the pace. So I imagine, but you can ask, I'm sure yourselves, ministers, that they were trading off the very long length of time it took to get started against trying to get some momentum going. We did get access to a lot of information about what the community thought, because we were able to see it from evidence of the inquiry. They had engaged with the compensation study that Sir Robert Francis had done a couple of years earlier, and on which Sir Brian Langstaff had reflected in making his recommendation about compensation. And in that, are summaries of what the recognised legal representatives suggested about the scheme. So we did read all of that and take that into account, but it was no substitute for actually having a discussion because it was secretive and gave rise to suspicion in circumstances where, for very understandable reasons, trust was extremely low. So I think it would have been much better to have been able to do that.
And I just wanted to put to you as well some of the assertions and examples that Kate, Burt raised, in particular some of the bandings, and I appreciate you've said that it was based around a sort of a clinical negligence style awards process, whereas from her perspective she doesn't see, or has said it has not been explained how these bandings have been arrived at. Are there sort of clear examples and legal principles that you have worked to that just haven't been explained, or are there some decisions that have been taken that actually it's not possible to discern without being part of that, what you have said is not a very transparent process?
So we did our best in our reports to explain why we reached the bandings and why we did. Those reports, I think, were not really read at the time because they came out alongside a government explainer of the scheme, and quite properly the community focused on, well, what has the government decided to do, not why we recommended it. It's also the case that...
Sorry, are you suggesting that the information is there in the public domain, they just haven't found it?
I think they now see what... If I can give you a concrete example, which we explored in some length in the roundtables with the community on our second piece of work. There was a strong belief in the community that the expert group that I chaired had ignored the psychological impacts of the harm that people had suffered. And we had explained in summary terms in the first report that we had assumed that everybody suffered significant psychological damage. So we had not separated out psychological aspects of what was there. What we had done was to say, in order to try and address some of the points that Kate and others have made about the absence of records, we need to try to find markers that should be available to people in terms of evidence. And we thought those markers would be markers around the impact on people's liver disease. And then we said to ourselves, okay, if people had a chronic hepatitis condition, but it hadn't progressed further to liver cirrhosis or further still to cancer, what would be the likely range of impacts from that, which we drew from the evidence taken to the inquiry. So it wasn't, it was indirectly trying to understand the communities. And then we tried to compare those to the likely awards that courts would make, which are not made up of a sort of checklist. You get X amount for this bit of your injury and X amount for the psychological impact. They're much more holistic than that. So we did our best effort to identify those and match them. Those variations are relatively small parts of the overall awards. The large driver for awards is the impact on people's ability to earn and the impact on people's need for paid care support. And we also aim to extrapolate in relation to each of those severity bands what it was likely that people who had those conditions would have needed in terms of care, and what it was likely would be the impact on their earning potential. And those inferences have broadly stood up, even after the further engagement, in terms of roughly what proportion of earning capacity would have been lost. And that enabled us to produce a tariff approach to financial loss. And I think the frustrating thing about our inability to communicate that is that you've heard about the calculator, which does provide a relatively straightforward way of people getting a ballpark figure for what the compensation is likely to look like. That is driven by all those judgments and recommendations. But those recommendations also drove a completely opaque set of legal regulations that even I find it hard to work out whether they actually implement the...
Do you think, sort of, in summary, because it's very complex, and obviously you've put a huge amount of work, effort and time into this, but do you think there is a risk that the approach taken has been too legalistic and has not done enough to engage with the people as part of that process, those affected by this?
So I think that the legislative structure that was created, which created an authority and regulations, we were advised would take the recommendations which we aim to write in a way that will be understood by the community into a set of powers and obligations and duties for the author. This is the discretion point that's there.
Yeah, so what I'm saying is, how did the government establish it with two legal, I appreciate this is a legal matter, but actually it is a government compensation scheme, and it's being approached like a court case for each individual, and is that perhaps the challenge that we have here?
So I don't think it's wrong for the government to say what would a likely court event outcome be. I think, so in that bit, I think that is a reasonable legalistic benchmark.
Yep.
The nature of the constitutional law requirements.
Sorry, I guess what
and the lack
I'm
of discretion
is,
has become
does it
unduly
lack
legalistic.
transparency? Which in a court case, when you're against the other party and you don't have full disclosure, you have to try and battle it out. It's almost set up a battle amongst the victims and the compensating authority, and that it feels, and from the experience of the evidence that we took from the previous panel, that's how the process feels for the individuals, to the point where they're now asking all for legal representation in order to navigate the process. So I appreciate I'm probably no longer asking you a question. I guess my question is, how do we get that balance between allocating a payment that is fair and just, whilst protecting the public purse as well and making sure it's fair and just to the taxpayer as well?
So I think if you had already had in place a redress authority, then the constitutional law requirements about how many tiers down you can delegate discretion would have been much less complex. The regulations would have been much simpler, and they would have looked much more like...
What does that mean if you already had a redress authority in place?
So because you had to... Because a new body was set up, to which Parliament then delegated powers, my understanding of what we were briefed was that you have constitutional law problems about how much discretion you could create. But if you already had an authority with the power to create a scheme, it would have been much less constrained and would not have had to create the same level of regulation. So that was the briefing that we were given.
So in answer to the first question, which is, how can the government best design and plan compensation schemes, have an independent authority, and then the detail of how much would be administrative differently? Okay, that's helpful. Thank you.
Thank you, Catherine. Sarah Green, please.
Thank you, Sir Geoffrey. Shaila, may I turn to you and ask what lessons has your work identified about the operation and administration of compensation schemes?
Yes. I think what our work and what my research has found is that sort of what supports fair and effective decision making is having an independent decision maker. So very much my research focused on the Windrush Compensation Scheme, and that is administered by the Home Office, which is the perpetrator of the harm. I can go into that in a bit more detail and talk about some of the post office schemes, because they're a bit hybrid, as I call them. They're not pure post office. So I think having an independent decision maker, and for that decision maker to have available appropriate experts to advise on eligibility where it's needed. Sometimes eligibility, so getting into the scheme, isn't necessarily complex. It is complex in Windrush. And also the amount of loss or harm that's been suffered. I'll just caveat that by saying the second part does depend on whether you go down a sort of a fixed sum route or you go down a assessment route. And I want to talk about that because I think that's an interesting proposition that should be considered in any scheme. So I actually think the Infected Blood Compensation Authority is actually a better example of this, because it is an arm's length body. From the National Audit Office report that I read, I think the satisfaction rates are higher than all the other schemes that I've looked at, in particular the Windrush scheme. So because the way the infected blood compensation scheme works is you have a case manager who's assigned. It's interesting, this case manager is a non-lawyer, and I think that's relevant just to mention because all of the schemes, the decision maker, the first decision maker is a non-lawyer. And then thereafter, that case manager works very closely with the affected person. And whilst the difficulty though is that the standard of proof applied in the infected blood scheme and other schemes is the balance of probabilities. But because you have an independent decision maker and there is funded legal advice, what our recent research has found is actually there is sort of a negotiation process in understanding what the level of loss is. And for example, that process, so the independence and having a bit of a buffer, i.e. the funded legal representative, actually our recent research found that most lawyers were saying that they were not taking cases to what we call an internal review, and very few had actually proceeded to a tribunal hearing. So the scheme is quite new in comparison, so it only started in October 2024. So that independence and having a lawyer navigate what is a complex legal system and standard of proof, and I want to get to that because I think that's a problem across all the schemes, is really in stark contrast to the Windrush Compensation Scheme, which is administered by the Home Office, and there's no effective provision for expert evidence. So in the infected blood scheme, the case manager can consult an expert, usually a medical expert, to assist if eligibility is an issue on loss. And the lawyer, the claimant lawyer, cooperates with the case manager to put questions and in terms of the evidence that's gathered. So there's no provision of expert evidence. Technically there is, but we are not aware of the Home Office ever actually having funded any expert evidence. So what you have essentially is that you have quite an adversarial system which is described. So I think one of the key things is whoever administered must be independent, and I think we actually do need to move away from these adversarial principles in all the schemes, and I can talk about what I mean by that, in particular by reference to the levels of evidence that all of the schemes have.
So I was going to ask you to follow up on the evidence point.
Yes.
So can I ask you to keep talking, basically?
So essentially, across the Windrush Compensation Scheme, the infected blood scheme, and all of the post office schemes, so those are the ones that I am familiar with, they have something known as the balance of probabilities. It's a civil standard. You could sort of equate it to having to prove your case, provide evidence to around 50% probability. Now, obviously that is an adversarial concept. In all the schemes, and particularly in Windrush, which I'm very familiar with, the guidance provides for a softening of that test. Because it does acknowledge the historical nature of the harm, the difficulties in gathering evidence, etc. But the reality is, so what lots of reports which have been written about Windrush, my report, the Justice reports, and also the recent research that I did with the claimant lawyers is that the majority of the decision makers in all these schemes, they're not lawyers. So they don't necessarily understand this sort of soft-edge balance of probabilities, as I call it. So the challenge is that there's a lot of toing and froing, there's elevated evidential standards, so it is complex. I think there's a way you can simplify it. There's a real question mark, I think now I've sort of reflected on all the schemes, whether there should be a balance of probabilities. You could have a lower standard, there's something known as a reasonable degree of likelihood. You could introduce some of the concepts that the earlier panel was talking about reverse burdens. But I think there's ways to simplify it and ways for the standard of proof to actually reflect that all these cohorts are victims of historical harm that's been committed by the state in each of these schemes, the state has destroyed the evidence, whether it's negligently or on purpose. So I sort of think that framework is very problematic. And also the flip side of that, which all the claimant lawyers said, so all these claimant lawyers, they're traditionally used to, litigating traditional damages claims. And they said there was a real difficulty in understanding some of the nuances of that threshold. So what you have is it makes the process more problematic and, in a way, litigious. I mean, certainly with the Windrush Compensation Scheme, that's been the case. Elevated standard of proof. Without a lawyer, because there's no funded legal representation for victims of the Windrush scandal, I would say it's virtually impossible to succeed, in my experience. I mean, there's a lot of evidence. Justice did a report which looked at the difference when somebody has a lawyer as to when they don't. I mean, for example, without a lawyer, someone might, for example, recover 11,000, and the average increase was usually 8 times to 80,000. So you have a complex scheme, which means that you really do need a lawyer, and if you don't have a lawyer, you are essentially, it's inaccessible.
That's really helpful. Thank you very much. Thank you, Chair.
Thank you, Sarah. Blake, please.
Thank you, Chair. Again, a question for you, Shaila. Could you just walk us through, please, how you think departments can better encourage and support claimants to come forward to claim for the compensation they think they're entitled to?
Yes. So I think if it helps, I can just summarise the methodologies that some of the schemes have used. So for the post office and the infected blood compensation scheme, one of the main methodologies was contacting the potential claimants. That's a good method to some extent for those schemes because the eligible cohort was more readily identifiable. But obviously there are difficulties with that because people may not respond to the authorities because of fear and so forth. I think the Infected Blood Compensation Authority, they also worked with impacted communities to do outreach events together. So they went out there together, which I think is a good option if those organisations have the trust of those communities. So with the Home Office, with the Windrush Compensation Scheme, it's a little bit more complex. So the Home Office didn't do that kind of official outreach. I mean, could that have been possible? I mean, potentially yes. There are documents that we come across when preparing claims where it's clear that the Home Office at some stage have identified that this person might be part of that cohort. So as to whether it's a bigger cohort, I mean, it probably ranges between 30 to 50,000 if you're being very, very generous, which is similar to the infected blood. So what was utilised, but it has not been completely effective, is the use of community organisations. The Community Fund enables community organisations to promote the scheme. The problem for the Windrush Compensation Scheme is twofold. The community organisations have had some success. Their success has been limited by the fact that there is inherent distrust in the Windrush Compensation Scheme. So even if a trusted person goes out and tells someone to apply to the scheme, there are already barriers because we have a 39% success rate, a very high refusal rate, and that is known in the community. So people are still sort of fearful. So actually the success of outreach is sort of hinged on, well, are you running the scheme well and have you got good engagement with your community?
And sorry to stop you mid-flow, but yes. Is part of the problem in some cases the lack of independence? Yes. So in this case you have the Home Office essentially caused the original harm,
Yes.
who's very much involved
Yes.
in the compensation process.
Yes, and also with, yes, it's also that, and also obviously
Sorry, and just to build on that, is the independence issue an issue that needs to be resolved in all examples? So, i.e., is that a fundamental issue in the establishment and the setup of these
Yes.
compensation schemes?
Absolutely.
Yeah.
So I think when we did a round table with victims from different schemes, and the independence point is fundamental. The perpetrator of the harm, from their perspective, should not be administering it for all those reasons. There is this inherent fear. For example, with the Windrush Compensation Scheme, the Home Office is still an immigration enforcement centre. So people, they're not even sure if they have status. So the likelihood of them coming forward is reduced. One point I do just want to make, it's more of a practical point. So I definitely think there needs to be trust, it needs to be independent. But the other point is that in terms of community organisations going out there and promoting the scheme, I think that needs to be done quite carefully. One of the points, and it's in the National Audit Office report, is that the scheme was promoted through a social media campaign and the eligibility requirements weren't clearly articulated. And the thing about Windrush is it is a complex scheme when it comes to eligibility. So, and in our Windrush Justice Clinic, we have found that. So the way we work to ensure that people are being given the correct information and, eligibility is correctly assessed is we work in partnership with our community partners. So, for example, we will train them on the eligibility requirements. When they go and do outreach, they will go in, it won't necessarily be, this is a Windrush Compensation Scheme event. They'll go to an event which is based in a church on something else, and they'll go and talk about the Windrush Compensation Scheme. And then the lawyers that are part of the Windrush Justice Clinic, which is lawyers from Southwark Law Centre or North Kensington Law Centre, will go and talk about eligibility. So we have quite a careful triage process. So I'm all for community organisations being at the forefront of that work, but I think it needs to be, where eligibility is more complex, I think there needs to be sort of good partnership with the legal experts, which is the model that the Windrush Justice Clinic uses because of some of these issues around eligibility.
And just building on that issue about independence, we heard in the earlier panel in relation to the LGBT financial recognition scheme, which is administered by the MOD, so in a similar situation. Now, these potential claimants are really difficult to find, and I guess there's a similarity there potentially with the Windrush claims. I don't know, you're an expert on that, but we're 6 months out in this particular scheme from it ending, and the MOD have only just decided to allocate some money to another party to go out and try and advertise. So when departments are doing that, what trust can people really have in these compensation schemes? I mean, how credible are they really? I mean, is there a risk here that departments are really just doing the bare minimum because they really don't want to pay out?
Unfortunately, that's the impression that the many different survivors from the different schemes do have. I think it's an understandable narrative. Sometimes it's also a true narrative. So I think that the key is, and I sort of going back to, I think it was the first question about when you design these schemes, and the earlier panel mentioned this, I think it is really critically important that the design of the scheme involves the impacted communities. And those impacted communities also need to be supported to sort of engage in that sort of what can be a legal process. I do think we need to sort of move away from sort of the having a legal process which is similar to a damages claim. I don't think it should be like that. So there are some examples of where that has been effective comparatively. So for example, in the Lambeth Children's Home Redress Scheme, there was funded legal advice for the Shirley Oak Survivors Association to engage in the design of the scheme. So that was in part effective in that the majority of compensation claims were paid. there were criticisms from the victims about the awards. And I appreciate there have been criticisms of the tail end of what happened with the infected blood schemes. But comparatively, the approach there is quite a model approach in comparison to, for example, the Post Office and certainly the Windrush Compensation Scheme. So I think that early trust can be very easily lost. I'll give a quick example. So in 2019, the government consulted a public consultation about developing the Windrush Compensation Scheme. And there was no funding for the impacted communities. They did contribute. And, you know, I know people who contributed to that consultation and they just didn't feel heard at all. So I think it's quite important to build some mechanism in where those views have an element of well, I want to say teeth, essentially. I think what has been better is, for example, the views of victims when there is a public inquiry seem to carry greater weight. Again, particularly in relation to the Windrush Compensation Scheme, where the impacted communities feel that small wins have been made, but the really important things haven't changed. So I think that mechanism for accountability about the views of victims, I think, needs to be built in somehow, proportionately, into the design of this independent scheme. I mean, you know, a public inquiry is desirable, and I think that one of the reasons why I think a public inquiry is desirable is that with both the Post Office schemes and I think the Windrush Compensation Scheme, when the scandals, I want to say, broke, I mean, following the litigation in the Post Office schemes and following the 2018 revelations, the government understandably wanted to move quickly to set up a scheme. And whilst I think it's important that schemes are set up swiftly, I actually also think both Windrush and the Post Office are examples about where maybe more time should have been taken to consider the nature of the loss that people suffered, consulting with victims in more depth, so you can design a scheme which may actually consider whether we should have two routes. One is a fixed payment and the second is a assessed route. Because the difficulty is that once that initial trust is lost, it is quite difficult to get it back from the community. So I suppose it's balancing the time you spend on planning. I mean, the infected blood scheme did have some quite useful measures that it introduced. For example, there was a degree of consultation and the introduction of interim payments. So they didn't wait to the end of the public inquiry for those interim payments to be set up. And also, I think I know there are criticisms of the test and learn approach, and maybe that can be scaled up. But I think there are some benefits. So you can start with some at least, and then, because with all the schemes that I've looked at, they are improved throughout, and I think we would want that, because until we can take learning from all these things, but all of the schemes are quite unique in terms of the types of losses and the types of evidence. So the test and learn approach, like I said, I think it should be scaled up, but I think it is a valuable approach, and when combined with consulting with impacted communities, in terms of that approach, I think it can be very valuable.
Thank you.
Thank you very much. Thank you, Shaila. Matt, please.
Thank you very much, Chair. Hello. I'd like to address this question to the pair of you, if I may, which is about what recommendations or changes that you would make to the government's approach to the planning and operation of future compensation schemes. This is where I get tested. So what I've heard is an independent authority for structure, non-legal caseworker to help the claimant, not having the perpetrator manage the scheme, good legal and non-legal partnership working, that the design should be co-produced with the affected community, and that ideally there is a public inquiry that is desirable as a starting point. But if there's other things and recommendations that you would make, please.
I don't think we want necessarily to say there should always be a public inquiry. There must be some public investigation, but a full-scale public government shouldn't wait if it knows that compensation should be made. I think one of the things about infected blood compensation, which doesn't quite come across in the NAO report, is the number of full starts that were made. And Sir Ryan Langstaff goes through the various ways in what things known as the Alliance House schemes failed to do the job effectively. And it shouldn't be necessary to have a public inquiry to acknowledge fault. So I don't think you should make that a prerequisite, but I do think it's a prerequisite that there is a clear explanation of acknowledgement of fault and what the compensation consequences are of that. I think the more detailed design work, which I agree needs to be co-produced, can't really work with without a bit of an understanding of what the intention, the aims and objectives are, and some of the parameters.
Yes, and sorry.
Please.
Yes, I just wanted to add. I think evidential burdens should be simplified, and I recommend moving away from this balance of probabilities threshold to a lower standard of proof. And being a former refugee lawyer, I'm thinking something more akin to reasonable degree of likelihood, or introducing elements of the reverse burden that we see in the scheme, some of the schemes in the report. I think there needs to be bespoke support services for victims as well. So I think this was discussed by the previous panel. The only scheme that has support, specific psychological support, is the infected blood schemes. The others don't. And I think it's important there for people to utilise. Impacted communities have raised this with me on a number of times. I think the other point as well, victims, they do want compensation swiftly, and they do want an apology as well. The apology on its own is redundant, particularly for the Windrush Compensation Scheme, or inadequate compensation. Oh yes, and I'm not sure if it was there, but there should be funded legal advice for all victims. Again, that's another. I think there's a lot of literature around the benefits of funded legal advice in relation to the well-being of victims, as well as helping with decision making as well.
Great, thank you very much indeed. Thank you, Chair.
Thank you, Matt. So, legal advice for all claimants. Looking at the NAA report, paragraph 111, page 19, says that the Home Office increased the number of caseworkers by around 20 and invested in training. By 2025, the backlog was reduced to 595 cases in progress. It then goes on to say a single casework approach under which each claimant has a single point of contact throughout their claims process. So is it important, is it necessary in the first instance to have legal advice, or is a simple caseworker, albeit trained, a good start?
So I think I would say that funded legal advice from the outset actually can help speed up the process, front load the case. The reason is that I suppose ideally you'd want a less complex, appropriately legalistic system, and the challenge is that even with the Infected Blood Compensation Authority, which is one of the better schemes, there were still challenges understanding that. And for victims, there is, even though it's an independent body, etc., there is still sort of fear and concern. There is also academic literature which talks about the well-being benefits of having a lawyer, having a buffer for talking about things which are inherently traumatic. So I would say yes, from the outset, I think it's necessary. One example I just wanted to talk about, I don't think, if time permits, is an example of where having a lawyer is actually very beneficial, even where you have a fixed sum scheme. So in relation to the Horizon Conviction Redress Scheme, the claimant can either accept the £600,000 payment, or they can have their claim assessed. And there is funding available to legal advice available to decide, well, which route should I take? And it was very interesting when we interviewed lawyers who advise on that scheme. So they would advise someone, well, you know, whether you should take 600,000 or is your claim worth more? Even when somebody's claim was potentially worth more, victims were still just going down the route of £600,000. So I think it's very important, I think Sir Alan referred to this, that someone has that legal advice so they understand all their options and what the best thing for them to do is. They are very highly traumatised in terms of whether they're making the right decision for themselves. The lawyer assists them in sort of navigating that process in a way that I don't think even an independent case manager can't do. In my experience of working on Windrush claims, as well as just generally advising the public around navigating various legal processes, it's really quite overwhelming, even for quite a sophisticated or educated member of the public, in my view.
Jonathan, any comments on that?
So I think access to independent advice and support is crucial. I'm not persuaded that you couldn't design a scheme that wouldn't require it to be from lawyers. And had we not had those technicalities we were discussing earlier in the regulations, I hope we had designed that. I think the key thing I would say is there's a question about who is trusted and where that funding should go. So we were very worried about creating a compensation industry where people who really didn't have any relationship with this community would suddenly see an opportunity to tout their wares. You would avoid that if you routed the funds for legal advice and support through the trusted communities. So my preference, I think, would be to recognise the need for independent support and advice, to take advice from the communities about whether that should be specifically badged as lawyers or could be used differently. But it clearly would need to make sure it included sufficient funding for legal advice to be given. So I wouldn't want to specify it's always legal advice. I would want to specify the community needs access to independent advice that is funded as part of the scheme.
So final question for both of you really is, obviously this afternoon we've been genuinely interested in the existing schemes, but one of our main tasks is to try and come up with some recommendations for future schemes. Unfortunately, future mistakes that the state will make and compensation will need to be paid. And in designing those schemes, I'm wondering what advice you've got for us, and particularly this issue of trust, taking it away from the lead ministry that actually caused the problem in the first place, Windrush, Home Office, etc., and whether a sort of government permanent standing delivery authority could be there, perhaps to deliver, but perhaps also to advise on the design as well.
So I go first?
Yes, please.
So I think it should be possible to create a sort of broad typology of types of schemes that are required. So some have to just acknowledge and recognise the loss, and a lump sum payment may be what's appropriate there. There are some where victims have major needs, and those needs need to be addressed, and then there's a question of the interaction between other welfare and support processes. And I think there are some where, as with the affected blood inquiry, you're trying to mimic a court process because it's very clear that people have been damaged in a way that would usually attract personal injury claims, and you shouldn't have to go through the treadmill to do that. So I think the first task would be, could you, with the experienced communities from previous schemes, identify not quite off-the-shelf schemes, but a set of issues that ministers could have as a blueprint, and they would say, we are asking for a scheme broadly of this type, and then you would be able to co-design with the relevant communities. I think the second thing is that We worked hard to set out our approach to evidence. We were given the balance of probabilities from the inquiry, but we asked ourselves about, you should only ask for evidence which was likely to be there. You should only ask for evidence that would actually answer a question that would change the compensation that was there. You did need, because of it being public money, to have some sense of verifiability. And you needed to be really clear that you should only ask people to come up with things that were proportionate to the need for compensation. Now, they might not be precisely right, but I do think a redress commissioner or body would be able to go to communities and say, we have a starting point which says these are the approaches to what is required of evidence, and that could include the point about the onus and burden of proof that you've heard. So I would have thought you could create a structure which would not take away from the communities their ability to do detailed design, but could be more realistic about the scope of that work and get it targeted and not raise expectations in an unrealistic way. If all that was in place, it should be possible to do the work a lot more quickly. So that would be my sense.
What would be the order of this? This sort of body would look at it, come up with a design. It's got to have some statutory underpinning of some sort, hasn't it? So they would make recommendations to the department, the minister?
So my sense of the ordering is a scandal of some sort emerges. It becomes apparent that the government needs to respond to that. It would be able to go to a standing redress commissioner and say, what are the range of options that we might consider? But it would need a democratic mandate for that to be actually commissioned to do the work. That commission would require the redress commissioner to work with the relevant communities to do the detailed design work. But you would expect ministers to say, we can see that these people need supported, or they need recognition for the wrongs that they have suffered. So there would be a sort of broad typology of the ask is of this nature. And I think that would give us the ability to get quite quick answers about the shape of the scheme, because most of these communities have got a pretty good sense of what redress needs to look like. So I think you would need to keep the Democratic Commission, but you would need an option available to say there is a limited range of approaches to this, and ministers need to say this is the type of approach that you should set off on.
I'm going to come to Shaila obviously in a minute, but one further question. I don't know whether you heard the previous hearing, and Blake, who's obviously had to go to the chamber, has referred to this. There is a cut-off date of, I think it's the 12th of December this year, so 6 months away. Do you think a government should have a cut-off date like that, or should is it wrong to have too tight a cut-off date?
So I think so that was the LGBT, that was the MOD,
yes,
yes, yeah. Not the blood scheme. I think there comes a point when, if you have set up, so if it were the blood inquiry, there comes a point where the investment in the case managers and the volume is not justified by the number of claims coming through. But I don't think you would have a cut-off that stopped people claiming. You would need a legacy. Again, if you had a redress commissioner, you would have somewhere a scheme could be deposited, if you like, for legacy claims that have been missed. I think whether a cut-off is a plausible thing to do, my view is that it depends on whether you are confident that there is sufficient awareness. So I think you're seeing David Foley later on in the week. There seems to be a reduction in the number of people now registering the intention to claim for the blood inquiry, and that might give a bit of a measure of what proportion of people the modelling suggests ought to be able to claim, are likely to claim. And then we need to ask the question, are there people there who don't know they could claim, or are there people who do know but have chosen that they don't wish to do that? I think it's reasonable to come to a point where you wind down the infrastructure, but not to put a guillotine to say that people who would be eligible can no longer claim.
Very helpful. Last word to you, Shaila.
Yeah, so sorry, Jeffrey, if it helps you, I think many of the schemes that I looked at, there was a cut-off point, and they were always extended. So I don't know how pragmatic it is.
Yes.
I don't know if it's a fiscal planning, when there are planning assumptions and there are allocated budgets. I don't have anything particularly to add. I do concur with Sir Jonathan's comments. I suppose the only point I don't know if Sir Jonathan made this exact point, but I think there should be an independent standing body to devise these schemes, and they should be there should be set up with an interdisciplinary expert panel. I think the impacted communities, we have a term at King's, it's called experts by experience. They should be on that group, and I think also there should be maybe a advisory group which is made up of other experts, including the impacted communities from other redress schemes, because as we saw from the last panel, there's a great deal of learning and knowledge, sadly, for those individuals as well. So I don't have anything to add. I agree with all the points that Sir Jonathan made.
Do you have any further questions? So if not, can I thank you both very much? You've given us some, again, very valuable evidence. The last panel, if you like, was the nuts and bolts. You were how you build a building. And I think it's been very valuable. We will, of course, as you know, as you've already referred to, as Jonathan has referred to, be having the permanent secretaries in on Thursday to give us further evidence on what we've heard. But can I thank you both? You're very busy people. An uncorrected version of the transcript will be available in the next few days if you wish to make any changes. And we will produce a report having heard all of the panel's evidence in due course, which I hope you will look at and let us have your comments. Would be really valuable. But again, very grateful for your contribution this afternoon.